AI and big data involve the use of very large amounts of data, and a lot of the data being collected for use with AI is personal data. As a result, we have to think about whether people are aware of the data being collected, personal data being collected about them, and that they have choices about how that personal data are used and shared. A lot of companies are advancing their ability to handle personal data by going through processes to understand what kind of personal data they have, how they're going to handle it appropriately, and how they're going to share it under what conditions. They may have risk because they may have data sets that they're not aware of. Maybe people have access to that data set of personal data that they wouldn't have intended if they were asked, should this group have access to this kind of personal data? And as a result, then they're not fully aware of the legal risks that they have. GDPR protects personal data of individuals who are located in the European Union. GDPR says that if personal data are being collected, then individuals have to be notified of what kind of personal data are being collected, and that personal data need to be protected from a security perspective. HIPAA is the Health Insurance Portability and Accountability Act in the United States. There are regulations that are issued under HIPAA that require the protection of the privacy and security of what is called protected health information. So health records is what we're talking about here in the United States. You can take out identifying information, as we've talked about, from the data sets so that you don't have anything to tie that record in the data set to an individual. It's no longer personal data under GDPR then. It's no longer protected health information under HIPAA. And then it can be shared much more freely. But you have this possibility of other data sets being used in combination with the supposedly de-identified data set to re-identify it. And then it should be subject to the protections of GDPR once again, or subject to the protections of HIPAA once that re-identification takes place. When you have a business-to-business deal, you have to ask the question first, am I involving in this business deal personal data? There's two thoughts that need to go into an agreement. One thought is identifying applicable laws that protect the privacy and security of that personal data. And the business that's providing the personal data needs to make sure that the company receiving it is going to comply with the applicable privacy and security laws. And the third piece is then involved with making sure that there are legal contract pieces in place to comply with the applicable laws relating to the handling of personal data. So some of these laws like GDPR and HIPAA require that certain kinds of contracts be put into place between the sender and recipient. Those compliance pieces require specific types of contract forms to be agreed to by the parties, and those get negotiated, and hopefully they will come to a deal in which the sender and recipient will put into place terms and conditions that comply with the law that will protect that information from a privacy perspective and legal perspective in compliance with applicable privacy and security laws.